नमस्कार. आयच्या डिबेटीत तुमकां सगळ्याक येवकार. विशय म्हाका दिसता आज आमी गुंतागुंतीचो घेतला इतल्याच कारणा खातीर कारण लोकांच्या तकले भितर एक अफुसां वाचची न्ही म्हण. 2 सप्तकां आदी हायकोर्टान एक ऑर्डर दिली जातूंतल्यान हायकोर्टान अशी रुलींग दिलें की चर्चीचो जो अधिकार आसता मॅरेज एनलमेंटाचो तो अनकॉन्स्टिट्युशनल थारायलो काडून घेतलो. आतां चर्ची सारकी सामाजीक आनी धार्मीक संस्था जाचो इतलो समाजा भितर खोलायेन वावर आसा आनी संबंध आसा तेन्ना असो जेन्ना एक जजमेंट येता तेन्ना ताजे नक्की समाजाचेर परिणाम कितें, प्रॅक्टिकल लग्नाच्या एनलमेंटाचेर परिणाम कितें आनीक जें जालां तें बरोबर चूक हाजेर आमी भासाभास करतात. 4 मानेस आसा स्टुडियोंत. म्हजे बरोबर पयली आसात गोंयांतले नामनेचे आदवोगाद शशिकांत बाब जोशी, स्वागत तुमचें. दुसरे आसात जाणी ह्या मॅरेज एनलमेंटाच्या कोर्टाचेर बसून जजमेंट्स दिल्यात ते फादर मौझीन अतायद, स्वागत तुमचें. तिसरे आसात जाणी ह्या केसी भितर आर्ग्युमेंटय घाले, रिप्रेझेंट आर्चबिशप, ते गोंयांतले नामनेचे आदवोगाद झिलमन पेरेर, स्वागत. आनी चवथे आसात आमचे बरोबर नामनेचे आदवोगाद गोंयांतले आनी जांचो व्यू ह्या डिबेटा खातीर तितलोच म्हत्वाचो एडवोकेट राधाराव ग्रासियस, स्वागत. झिलमन, आय विल स्टार्ट विथ यू बिकॉज यू आर्ग्यूड इन दिस केस. जजमेंट आयकली तेन्ना लोकांक कळपा खातीर, सामकें सामान्य लोकांक कळपा खातीर, हाऊ डू यू एक्सप्लेन दीस जजमेंट एंड were you surprised?
See, I am not surprised by the judgment because I take it that the judge decided, putting his conscience in the matter, and he has conscientiously decided the matter. Now, see, the issue is this: whether Article 19 of the family laws is valid or invalid under the Constitution. Annulment in the olden days would only be on incapacity, mental incapacity, on serious disease, on these grounds, or there was no contract at all. Under contract was obtained on a deception. So it was on that count that that to recognize that that sacrament, that Article 19, the Concordat was agreed upon, incorporating Article 19. Now, what Article 19 meant is that this marriage, once the annulment was decreed by the ecclesiastic court tribunal and confirmed by the Holy See, which was the appellate tribunal in a review, which was compulsory, then only the decrees would be sent to the High Court, then the Tribunal de Relação, and Tribunal de Relação would pass on the judgment, see whether the procedure was complied with, whatever was there was authentic, and send it to the registrar, and it would take effect of an annulment in law.
What has been done is Article 19 has been set aside to the extent of judicial review. It has been read down, as my learned colleague just now said. What has been done is, in that there was no opportunity of cross-examination. There is one of the prohibitions was there. There was then another thing is, if the bail person, that is what I am saying is, one of the parties was being examined before the ecclesiastical court, the other side could not remain present. The other witnesses also could not remain present. He had to be examined individually. Now, all this has been in principle what was happening was there was violation of principles of natural justice. That is why that is the bigger problem that has erupted here, and as a result of which, because of violation of Article 14 and 16 of the Constitution of India, this has been held to be ultra virus. But it does not mean that hereafter there is no jurisdiction for ecclesiastical courts. Ecclesiastical courts will continue to have jurisdiction, but what they will have to do is they will have to comply with principles of natural justice. That is, one is when you depose, the other side will be able to cross-examine you. When you produce your witnesses, other side will have also an opportunity to cross-examine those witnesses. In addition to that, those other parties, rival parties, will be allowed to participate in the proceedings. They will be able to sit in the court and see the depositions whether they are recorded properly or not. This is what has been done. Now, one more thing that was happening was, now as my colleague just now said, that there was confirmation required by Vatican. So, that was also required. So, now all those procedures will continue, and that is only the change in the law as far as the present situation is concerned.
फादर तुम्ही कशें पळयता त्या जजमेंटा कडेन?
पयले सुवातेर आमी इतिहास समजूंक जाय. इतिहास असो, इगोर्जेचे काजार म्हणटा पळय ते, लग्न म्हणटात पळय ते, लग्न करता इगोर्ज. पूण ते इगोर्जेन लग्न करूंक एक नो ऑब्जेक्शन सर्टिफिकेट जाय, रेजिस्टर सिवील म्हणटात ताका, हाचें सिवील रेजिस्टर तांचें जाय. तें मेळ्ळ्या बगोर इगोर्जेन लग्न करूंक जायना. आनी मागीर ताची सर्टिफिकेट पळय आसा पळय ती रेज सिविलान धाडटात, आनी थंयसर ते दोन आदीं बरयताले जाता, आतां ते फायल करतात. आनी तेन्ना थावन सिवील इफेक्ट्स हाका ह्या लग्नाक मानून घेतात. धाडला तेन्ना थावन न्हय, इगोर्जेन काजार जालां पळय तेन्ना थावन. सो विथ रेट्रोएक्टीव इफेक्ट्स. सो दोन काजारान, एक इगोर्जेन आनी दुसरें सिवील रेजिस्टर, एकूच काजार इगोर्जेन आसा पळय तें. आनी पाद्री पळय हें काजार कोत्ता वो काजाराक आजीर जाता, वो सिवील रेजिस्ट्रार न्हय, वो इगोर्जेचो म्हणयारी. म्हणटच एकूच काजार. पयलें सिविलाचे फॉर्मालिटीज करतात आनी मागीर हें. आतां जेन्ना पळय काजार म्हणजे रद्द करता तेन्ना, एनॉलमेंट करता पळय तेन्ना तसलोच प्रोसेस तो. इगोर्ज रद्द करता, इनवॉल्व्स द सिवील ऑथॉरिटीज and they execute it civilly. It is wrong also to say that the church is conducting its proceedings and conducting its judgments, marriage cases under Article 19 of that law. No, Article 19 only comes for the civil execution of the ecclesiastical decrees of annulment. आता पळय, ecclesiastical decrees of annulment गोंयां तशें मुंबय, गोंयां तशें केरला, गोंयां तशें सगल्या आख्ख्या संवसाराक जंय क्रिस्तांव आसा एकूच तें. The High Court is definitely within its right to state whether that Article 19 is ultra vires constitution or not. It is within its powers. आनी तें तर काडलें, म्हाका व्हडलो हरकत जायना.
Okay.
The church continues to
Do its duty. Radharao?
duty conducts the proceedings.
Conducts the proceedings, yeah.
And that does not involve.
You see, what happens is the marriages are performed by the church after the civil registrar certifies that the persons are qualified to be married. But under civil law, there is divorce and there is annulment. Under church law, there is only annulment. There is no concept of divorce. So, as a civil citizen, I have the option of getting my marriage dissolved by divorce before the civil court, or and getting it annulled by the church. The consequences are different. Now, as far as these directions on cross-examination, I don't think that is the correct thing the High Court has done. You see, what happens is, the church is an authority by itself. Hinduism, Christianity, Muslim, these are religions. These are not democracies. Each religion has its own basic principles of marriages or dissolution within its own fold. You cannot direct them to follow democratic process. At the most, High Court could have said that these orders of the ecclesiastic court are not binding on us. We are not going to implement them. But these directions issued to the church to allow cross-examination, I think is completely contrary to good sense. You see, the church law cannot be changed only for Goa. It is a law for the whole country.
You agree with this?
For the whole world. No, let me finish. See, therefore, the High Court could have said that unless you comply with these orders will not be executed by the civil authorities. So that parties go to the ecclesiastical court, get a nullity, and then go to the civil court also, or simultaneously go and get a decree which will be executed. That I think would be the fair way of doing it. I don't see how the High Court can direct the church to change its own rules. Although I don't agree with what is happening in the church sometimes. These annulments are done almost in secrecy. But anyway, that has been the practice of the court, and I don't expect the church to follow democratic principles, or anyone, either Islam or Christian. It is not so, because they have their own set principles. No?
Okay.
So that I wouldn't agree with.
I will just,
Yeah.
in between,
Then
I
I'll
just
go to
wanted to
the-
open up another part of it. Now, in Article 19 provides basically that the courts cannot review, revise, or there is no provision for judicial review. That was specifically barred in terms of Article 19. That is another part which comes up. Now, that means ultimately the High Court, or the senior most judge of the High Court, was supposed to transmit the order of the ecclesiastical courts for the purpose of cancellation or registration of marriage was brought down to a level of just executing court.
Yeah, just executing it.
Just executing court, or some sort of a post office. Because if there is no power of revision, if the court cannot review it, judicial review is not provided for, then it goes to violation of Article 19 of the Constitution.
ओके तुम्ही कशी बघता दोन्ही मुद्द्याकडे कशी बघता एक राधा बनकाळीचा मुद्दा आणि
See, basically that what the High Court has done, tested this provision of Article 19 in the touchstone of Article 14, because the law can be declared as ultra vires only if there is no power, and second thing, if it's arbitrary. Now here, on a touchstone of violation of natural justice, the High Court in its wisdom, the division bench has held that this law, the provisions of Article 19 are no more law. Now what is the consequence of it?
Yeah.
Whether ecclesiastic courts are barred from adjudging cases
Yeah.
on annulment, I say no. It is not so, because no Christian can remarry unless the marriage is dissolved or annulled. The canon law does not contemplate for divorce, because the marriage is a sacrament. Now what has happened is this, that the High Court has held that this provision is bad, it has no effect. Now therefore what is the consequence? Annulments done by the church will not have civil consequences anymore. Second situation which arises is that you can go to the civil court if you want it to have a civil
No, if
consequences
you are
and
a
follow
goer-
the law,
Yeah.
follow the law which others have.
Yeah.
This was a special protection.
So the
for
question
goers.
is, which is a very practical
Yeah.
question, that if you are in Goa,
Yeah.
if you have done the annulment through church, whether you should go for the civil or annulment or divorce, or you should not.
Sorry?
If you are a Goan,
Yeah.
if you are a Goan Christian,
Yeah.
and if you have annulled your marriage in the church,
Yeah.
whether you should go,
Now-
can go is one part, whether you should go to the civil authorities for annulment or divorce, or it's not necessary.
See, I tell you what, if you want to leave, otherwise you are caught on a bigamy. If you remarry or live in any situation and have children, you are caught on a bigamy. If you do not get it annulled by the civil court.
Yeah, correct.
So therefore,
So
but,
that is mandatory also.
but to get,
Yeah,
Let him explain.
yeah.
but to get it, but for a Christian to remarry in church, he can only do if his marriage
Is annulled in the
is
church.
annulled. Father will correct me if I am wrong.
Yeah.
So
I-
therefore-
I just think Sashikant was
I'll
uncomfortable.
add one more aspect to it.
Yeah.
It is not that the civil court did not have jurisdiction to entertain divorce suits, even in case of Catholics.
Correct.
Civil courts could entertain, even I have filed the suits for divorce of Catholics on different grounds like fraud and
Yeah,
cheating
correct.
and all those other, basically fraud
Yeah.
at the stage of marriage. Civil courts could entertain the suits, could decide the suits independent of the canonical law.
Yes.
But ultimately what happens is, for proper cancellation in terms of the church, that they are required to go to the church and again take
And,
another
yeah,
divorce.
if you have to remarry, the annulment should happen in the church.
Yes.
Father, yeah.
Point.
then I'll go to Radharao.
Yes,
Yeah.
sure,
Yeah.
sure.
That's-
So
yeah.
He's a good friend of mine. Now what happened? This is annulment is done in the church.
The only priest is a friend of mine.
In the church.
Yeah.
In the church. You don't apply to the civil court for execution. If Article 19 is declared ultra vires of
Yeah.
the Constitution, then you don't go. And therefore, it is not civilly executed. And if it is not civilly executed, you will have to have a recourse like any citizen to civil divorce in the civil courts. Now, if for example, a situation may arise like this, the church grants annulment,
Yeah.
the civil court refuses. The church will not allow you to marry in the church because you require no objection certificate from the civil registration office to conduct the church, to conduct marriage in the church. The other proposition may be also the church has denied you annulment. You have got civil divorce. The church will not allow you to have the marriage in the church. If you want, and you are the Indian citizen, free Indian citizen,
Yeah.
have a civil marriage. Civil marriage.
Yeah. Radharao,
See what happens.
I think now picture is getting completely clear for the general public.
Yes.
Yeah.
Now what my colleague Zilman has not addressed is, now the question is of Article 19 being ultra vires. As I have pointed out, Article 19 no longer exists because the Concordat of 7th May 1940 has been superseded and a new Concordat is signed. So therefore, in the treaty between the Holy See and Portugal, Article 19 is no longer there.
Yeah.
So how can the court overrule something which is not there? See, this fact was not before brought to the notice of the court that the treaty itself is no longer in force.
Yeah. Zilman, you agree with this?
No.
Zilman Babu is smiling.
No, therefore, what I'm saying is,
Yeah.
you see, India has no treaty with either Portugal or with Rome, with the Holy See. So it was by virtue of that treaty
Yeah.
and by virtue of the administrative order of 1962 or something by which some Portuguese laws were extended to Goa, this law was there. But now that the treaty itself has gone, can it still be applied to Goans? That's a very good
How do you
question.
respond to that?
There's a misconception here from my good friend Radha in putting this proposition. I tell you why. Because this is a law. The Concordat is now immaterial. Because what happens is, this is a law which is a personal law to Goans, to this state, as far as Christians are concerned. Now, irrespective of change in Concordat, because the law has to be seen as it is in the statute
As it
book.
is applicable in the statutes. Yeah.
As it is in the statute
Yeah.
book. So, the change in Concordata in Portugal, it matters not. Now, the High Court has held, by the division bench or the single judge has held in a judgment, which I relied here, to say that Concordata is very much law. So, the Supreme Court is also held that canon law is law of the country. Now, therefore, see, this judgment has done two things. The judgment has unsettled section Article 19. And second thing, the judgment has gone and says that we can in judicial review the order of the ecclesiastic court, irrespective at all times.
So it has taken the powers of review.
No, not taken the power of review. The court has held that we have a power to review
Yes.
even these judgments of ecclesiastic courts.
Yes, correct.
Now, to that, my argument before the High Court was that this doesn't violate natural justice, because the canon law is a law which there is a complete provisions, there is a complete set of provisions as far as procedures concerned contemplated in canon law. And the judges are persons appointed by the bishop with qualifications prescribed. Then there are assessors, there are promoters of the
structure in
bond.
place. There is a structure in
That's
place.
right. Now there was no challenge in the provisions to the provisions of canon law by the petitioners in those petitions. But the High Court, in its wisdom, held it that yes, we can exercise the right of judicial review, even in judgments from hence now of the provisions of judgments rendered by the ecclesiastic courts at all times, because the natural justice should be followed. Now question would be that here these provisions are not under challenge. Now, and the second argument which has not been taken care of is that ecclesiastic courts are outside the pale of judicial scrutiny.
Yes.
That is as it been held by the Supreme Court in 67 in other cases.
Yeah.
That aspect has not been considered in the judgment.
वॉज मुद्दा हा जर आदाबाने काढला की कोर्टान जर आपल्याला व्यू दिला बऱ्या बट कोर्ट वॉज कोर्ट I wouldn't say violated
I will
but
answer.
overstep while giving instructions to the church. Yeah.
No,
Yeah.
it is not that way. Article 226, the powers of judicial review, which are vested in the High Court under Article 226 and Article 32, they are in the Supreme Court. This is in very many judgments, it is held to be a part of basic structure of the Constitution. On account of which, any law which can affect the public can be reviewed, any judgments, any orders
You are saying
passed.
High Court is within its powers.
No,
Yeah.
Yes.
See, I do not dispute the fact
Yeah.
that as a country for us, our law, the constitutional law prevails over everything else. No dispute on that count. Anything ultra virus of that constitution is bound to be struck down, whether it's tradition, custom or religious law. No dispute there. But my issue is that, you see, we as Catholics, we subscribe to the doctrine of the church. We get married as per the doctrine of the church. We get our marriage annulled as per doctrine of the church, which we accept.
Yeah.
We have no grievance there. Now, our constitution for as a civil society, we have the process of natural justice. We have the right to cross-examine. All that is there. I don't dispute that. That is for our civil law. But within the church, there is no. See, as I have said, the church is not a democracy. No religion is a democracy. So it has its own right. Can the High Court direct the church to change its principles, to change its rules by which...
You are saying their High Court has overstepped.
No, therefore what I am saying, I am very simply saying, all that the High Court can say is, you have passed according to your laws, which laws are not in consonance with the laws of the land. Therefore your judgment is not binding on us. Fine enough. Any party that wants cancellation of the marriage in the civil registrar will have to move the civil court, as is often being done by us, and get a decree for cancellation. But the church order shall be binding between the church and the married person. Why should the court dictate there that it should follow this principle or that principle?
So
that
the
is strictly our
final-
affair within the church.
You are completely agree with this.
I agree completely. And then I see a danger here. Suppose the civil courts enter into such internal matters, there is no way of putting an end to it.
Putting an
what
end.
I'm saying.
Yeah.
Suppose tomorrow one lady goes to the court and says, ladies also should be made priests. What are you going to do? What are you going to do? Suppose someone is denied the sacrament of confirmation because of some reason, goes to the court. Can the court?
You are saying once court steps into that territory, there is no end to it.
There is no end to it.
Yeah.
And I feel, see, I would very much agree that the court is in a position to decide on that Article 19.
Yeah.
Because
but restricted only to that. Okay.
Article 19 is a civil law. Civil law.
Okay.
If you ask me,
Yeah.
the courts could have read down Article 19 and said that yes, the High Court in this judgment, yes, in a proper case, this provision provides for us to interfere because powers under 226, it has been held by the Supreme Court Constitution Bench, that cannot be taken away, whatever it is.
Yeah.
So that, because this is now under the ecclesiastic judgment and decree, it takes the force of law by virtue of Article 19.
Yeah.
But see, it would not also be right to unsettle it, possibly. It would not be, in my view, because the courts could have said, because Article 19, what it provided, that administratively these judgments, once confirmed in appeal, now appeal went to the Metropolitan, goes to the Metropolitan Bombay. That also came for consideration of High Court, and High Court says yes, it can be done. That these judgments on the administrative side, once the procedure was followed, seen to have been followed, and embossed with the seal of the Archdiocese and the Metropolitan Tribunal, that yes, those decrees could be held to be enforceable. Now, if there was any challenge in a proper case, the court's hands would not be fettered under 226.
Yeah.
So, to that extent, unsettling this would create serious repercussions, because the Catholic community will really find in a flux, because this was meant to give personal protection to the family laws of the community.
Correct. Yeah.
And
I will.
Final.
just
okay,
one, and therefore, what would happen is that this could, the power of the court to look into those judgments obtained by fraud, nullity and all are not taken away under Section 9 of the Civil Procedure Code. So, they would be always there.
That system would parallelly function.
That's right.
Yeah. Final
see,
बाकी एकच
see,
घालूया
I-
या
all right.
इशूचेर की तो जो राधाबाबान जो मुद्दो काढला की once you get into this territory, once court gets into this territory, there is no end to it. म्हणून फादराने म्हळें. You agree with this final?
No, I cannot agree to it for the simple reason. See, everybody, if your deposition has to be believed by anybody, you should be cross-examined by the other side. One. Secondly, behind the back of the other party, you are deposing in the court. The other party should be a party before the court, but one has the right to know whether what is said is properly recorded or not. Equally, cross-examination should also be allowed to be done. So ultimately, what is important is truth should prevail. Otherwise, there can be misreading.
म्हणजे वेळ सारखो सोपला क्विकली.
See, I am not disputing
Yeah.
that you have a right to cross-examine, but that is under civil right, under civil law.
Yeah.
The church does not give you that right. If you accept a church law, you have to accept church annulment for the purpose of church marriage.
Yeah, it is your own personal choice of
Yes.
accepting or not
Exactly. So
accepting
why
it.
should the court interfere there?
म्हाका दिसता बरी डिस्कशन जाला आणि एक लोकां मुखार जशें झिलमनवाल म्हळें we did not conduct this exercise to alarm the public, but to create awareness and educate the public on this judgment. आणि सगळी तासां तुमची मुखार आयल्या एट द सेम टायम जर फादरान बरें एक्सप्लेन केलां की किती केल्यार किती जातलें ही दोन्ही सिच्युएशन्स तांणी एक्सप्लेन केल्यात आणि तातूंतल्यान इंडिविज्युअली प्रत्येकान कशें डिसिजन घेवपाचें तेंय एक्सप्लेन केलां. म्हाका दिसता ही गजाल तुम्ही ही डिबेट पळोवपाक शकतात, समजून घेवपाक शकतात आणि प्रत्येकाच्या तकलेंतलो डावट हातूंतल्यान क्लियर जातलो अशें हांव मानतां. तुम्ही आयले इतली बरे तरेन विस्कटावणी केली. थँक्स अ लॉट. पळयत रावात प्रुडंट. नमस्कार.